Today's daf is daf mem ches, and we'll start on the last line on daf mem zayin amid beis, where we stopped yesterday. Mosiv Rav Huna bar Yehuda. So just to review, Rav Chizda's opinion is if you have two witnesses that contradict another two witnesses, which means that by definition one of the two pairs of witnesses is lying, then we have to exclude both pairs of witnesses. Each pair has now forfeited his cheskes kashrus. So Rav Huna bar Yehuda is now going to raise an objection against Rav Chizda from a case of edus on a new moon. So that back in the day, today we have a calendar already that was organized by Hillel Hasheni, but originally it was Kiddush al Pi Re'iyah, means that they were Makadish the Chodesh, and they determined Rosh Chodesh based on the testimony of two witnesses. Now the two witnesses, obviously, Reuven and Shimon, they have to testify that they saw the moon at the same height. So now we begin here with a brisa on Daf Mem Ches Amud Aleph. Echad Omer Gavoa Shtei Mardaos. They used to measure height by a thing called a mardaos. The mardea was it's called in English a goad, which they used for an ox. Anyway, it was a certain kli, and it was very tall. And this one witness, we'll call him Reuven, he says that the height of the moon that I saw was 2 mardos. V'yechad omer shalosh. The other aide says it was 3 mardos. Now, the discrepancy between that and that is very limited, and therefore, a dusam kayemes, we can reconcile the two eidim and say that one of them made a mistake, or maybe it was equidistant between the 2 and the 3. However, echad omer gimel, v'echad omer hey, if the discrepancy between the two witnesses is that much greater, it's a difference of 2 mardeos, and then it's very difficult to say that one of them made a mistake, and therefore we conclude that one of them is lying, is a dusam v'telu, we have to throw out and void the edus. However, umitztarfim li edus acheres. If Reuven can find, let's say, Levi, and Levi will testify and support the edus of Reuven and agree that it was only 2 mardos, or for that matter, if Shimon finds another aid that testifies that it was 3 mardos, is then we could be Makayim the edus based on 2 witnesses that can be reconciled. Now what does it mean, li edus acheres? Lav li edus mama. In other words, why did this brisa use a strange language called edus acheres? Forget about edus acheres. Just address the head-on case of this Kiddush HaChodesh, meaning that the other aid, we'll call him Levi, agreed with either Reuven or Shimon as to the height of the moon, and therefore we can reconcile those 2 eidim as far as edus on Kiddush HaChodesh is concerned. Why edus acheres? And the Gemara now is sort of darshaning the language of the Bryce edus acheres as referring to edus mama, which means that according to this diuk that we have in the Bryce's language, we're going to come to the conclusion that one of these 2 eidim could link up with, call him Levi, on a monetary case. Now, according to Rav Chizda, each of those 2 eidim that contradicting themselves, Reuven and Shimon, have forfeited their cheskes kashrus, and henceforth we cannot rely on them in any edus. So how could it be that Reuven would link up with Levi or Shimon with Levi to testify in a monetary case? That's against Rav Chizda. Omar Rava, hu v'yachem mitzar v'leiches aches rosh chodesh. No, the words edus acheres, that phrase, does not necessarily have to be subject to interpretation as referring to some other edus entirely, but edus acheres means that there's another Maisa edus that's going to be testified in Beis on this very same issue of the new moon. Now, you may ask the following question. Well, are you saying that Ruvain could link up with Levi if Levi coincides with Ruvain's testimony as far as the height of the moon is concerned? But wait a second. What about Shimon? Shimon contradicted Ruvain, and because of the very wide discrepancy between the testimony, the story that was told by Ruvain, and the testimony of Shimon, we determined that one of them is lying, which according to Rechisa means he forfeits his netmanus, his credibility in any case henceforth. So how can you link up Ruvain with Levi on this Kiddush HaChodesh when Ruvain's status is that of a apostle? He's disqualified. But the answer is because when Ruvain links up with Levi, they become a kat, two witnesses that has magical power. And that power is such that Shimon, who's contradicting any one of those two Eidim, is outnumbered completely. And his testimony is worthless. So if you have two Eidim testifying X and one aid comes in to contradict X and says not X, that one aid is worthless. What happens here is that a man comes over to a merchant and he says to him, I want to buy a dinar's worth of produce. And then after the produce was delivered, the merchant says to the balabayas who made the order, hey, you didn't pay me yet. Where's the dinar? The balabayas responds and says, I did pay you. And the Mishnah in this case records a machlokas between the Tanakama and Rabbi Yehuda. According to the Tanakama, we'll call him the customer, meaning the balabayas who made the order, takes a shvua that he paid, and he's off the hook. He doesn't have to pay. And that's based on the principle of muhzakus, that, the burden of proof is on the merchant to prove that he in fact never got paid, because he wants to be motzi momon from the customer. Comes along Rabbi Yehuda and he says no. Rabbi Yehuda says that there's a different kind of muhzakus here, and that is, it depends where we find the produce. If we find the produce has already been totally delivered into the, we'll call it the storehouses of the customer, then the customer is believed and he doesn't have to pay. But if on the other hand, the merchant is still holding on to that produce, let's say it's in his silos or his storage houses, then he's called a muhzak. And therefore we believe his claim that he wasn't paid. That's Rabbi Yehuda. Tanya, we learned in a Brisa. And now we're going to try to understand Rabbi Yehuda. Omer Rabbi Yehuda a Masai. When does the customer have the credibility to take a shvur that he paid up and he's believed? That's bisman shaperos tzvurim munachim. In other words, the peros are somewhere, gathered together between the reshus of the customer, the balbayis, and the reshus of the chenvadi of the merchant. So the merchant doesn't have chazaka, and therefore Rabbi Yehuda is saying that if he wants to get the customer to pay up, is hamotz mechaver, he has to bring proof, and therefore the customer is believed to say I paid up if he takes a shua to that effect. Aval if shilan bekupaso lachorov. If, on the other hand, the merchant has already delivered the produce into the kupaso means like a bag, so it's already in the bag, or we would say today in the bank account of the customer, of the balabayas, then if the merchant, the Chenvani, is claiming I wasn't paid, then it's Hamotzi Mechaver Lavaraya, because we now have full muhzakus on the part of the customer. Number one, he is the one that's being sued to pay up, take money out of his bank account, write a check. And number two, the produce is already in his satchel, and therefore he's muhsal. The Mishnah goes on to say, Amar l'shulchani tainli. So they used to have a shulchani. Shulchani would exchange, is a money changer. And now, let's say the customer would give a dinar to the shulchani, and he would get small change in return. And now the shulchani claims, well, I gave you the change for the dinar, now cough up the dinar. And the customer says, I already paid you the dinar. Now, it's very strange that the shulchani would have already delivered the change, broken down the dinar into smaller bills when he didn't receive payment. You're a professional shulchani. People have to come in and give you larger bills, and then you give them in return, break it down, change it into smaller bills. So the fact here that according to the Tanakama Rabbi Yehuda, the customer is believed to say, I already gave you the amount of money that I agreed to pay you, and you gave me smaller change, whatever it might be, and he takes a shvua to that effect, that's a very, very big chiddush. And Rabbi Yehuda says, no, I don't believe for a minute that the shulchani would have given you the money without getting your money. And therefore, according to Rabbi Yehuda, the customer, let's say the balabais, wouldn't even have to take a shvua. He's believed that he paid up, he gave the higher bill, because the shulchani never would have given him the small change without first receiving the higher bill. Utzricha. Now, why do we need the Mishnah to record this second machlokas about a shulchani following the first record of the machlokas between the Tanakama and Rabbi Yehuda regarding the chenvani in the case of the produce, where the chenvani says, I already delivered to you the produce, now pay me for it. And we're going to have a machlokas between the Tanakama and Rabbi Yehuda about whether we believe the customer to have said, I already paid you up. We need both of them. Diashmin and Hakamaisa, if we only had the first case, namely the case of the chenvani, and we're dealing with produce, is the Gemara says, I would have thought that Bahach ka amri rabbanon mishum de peri avidi de markeve ke de markvilo mashulu. There's a certain pressing logical reason to believe the claim of the chenvani, namely that he delivered the produce even though he wasn't paid. As we said before, in the case of a money changer, he would never deliver the smaller change unless he received first the more higher bill, the higher amount. Now, what's this for to say that we might want to believe the chenvani, and there's a certain credence to his argument that he delivered the produce and wasn't paid, and therefore we have to force the customer who claims he already paid to take a shvua. That's because it's very, very possible that the chenvani would have delivered the produce. Produce rots and disintegrates with the passage of time. And therefore, if the merchant, the chenvani, wants to make a profit, he's got to deliver the produce ASAP, so that now if any rottage starts, spoilage starts, then it's the problem of the customer, because the deal is already clinched and he has possession of the fruits. So it's very possible, plausible, that maybe the merchant would have already delivered the produce without getting paid. Aval b'mos, but in the second case, the low markave, we're talking about currency, which doesn't disintegrate over the course of time, Ema Module Rabbi Yehuda, maybe the Chachamim would accept the view of Rabbi Yehuda that the customer who claims that he already gave the higher bill over to the money changer might be believed even without a shvuah, which was the opinion of Rabbi Yehuda. Maybe the Chacham would accept the opinion of Rabbi Yehuda. And therefore, I need the second case of the money changer. And now we take the same logic and just reverse it in the opposite direction. If we only had the Machlok Shin Tanakam and Rabbi Yehuda in the case of the money changer of the Shulchani, Bahakam Rabbi Yehuda, here's where Rabbi Yehuda says that we're going to believe the customer, and he doesn't even have to take a shvuah, when he claims that he already gave the higher bill over to the money changer. We believe him. And why is that? Because a money changer doesn't change money until he receives the money. He gets the higher bill of $100, and then he gives him 520s or 1010s. But in the case of produce, with regard to the chenvani, I might entertain the possibility that Modelahu Rabbanon, Rabbi Yehuda agrees to the Rabbanon and accepts the questionable, the questionability of the claim of the customer to say that he already paid up, because it's very possible that the merchant, when he claims that he delivered the produce without getting paid, there's a certain element of trustworthiness, shall I say, a logical support for his claim that he delivered the produce even though he didn't get paid, because he wants to get the produce out and delivered as soon as possible to avoid any spoilage, tzricha. So I need, in that case, to tell us that Rabbi Yehuda, nevertheless, even though there's a certain credibility to support the claim of the merchant, nevertheless, Rabbi Yehuda still says that the customer is going to be believed to say that he paid up for the produce and he doesn't have to take a shvuah. The Mishnah says, "Kshem sha'omru apogemes b'ksubasa, kein yisomim hayisomim lo yifparu." So now the discussion revolves around the case of a malva and lova and their yisomim. If the malva left a shtar in his possession, which is now taken over by his orphans after he dies, and the shtar testifies to the fact that so-and-so owes him a loan. Now keep in mind, if the father was still alive to collect this loan, then he would be believed without a shvuah, and the lover would have to pay up. And the reason for that is because he has a shtar. When a malva produces a shtar, then he needs no other support, no other testimony. So the Mishnah says that the yisomim of the malva can only collect from the yisomim of the lova if they take a shvuah. Miman. Vis-a-vis whom are the yisomim of the malva taking a shvuah? Ilemim lova, if they cannot collect the debt that was owed to their father, the father had a shtar, without them taking a shvuah that the debt was unpaid. Otherwise, without the shvuah, they cannot collect from the yisomim, the orphans of the lova. Doesn't make any sense, says the Gemara. Had the father been alive and he's holding on to a shtar milva, he would be believed to claim that the loan was not repaid, and he would collect from, whether it be the lova himself or after his death, from the yisomim of the lova, without a shvuah. And now you're telling me that the Yisomim of the Malva have to take a shvuah and the Malva himself would not have to take a shvuah? Says the Gemara Hachikam. Now we have to reinterpret the Mishnah. You know what? To the same extent that you want to protect the interest of the Yisomim of the Malva by saying, well, the Malva himself had a shtar, he didn't have to take a shvuah. Why should the Yisomim of the Malva take a shvuah? I want to protect the interest of the Yisomim of the Lova. And therefore the Yisomim of the Lova have a right to demand a shvuah because they don't know whether or not their father actually paid up this loan or not. So the Yisomim of the Lova have to be protected. And therefore, Yisomim and Yisomim lo yiparu ela b'shvuah. Now, let's understand that there's a fundamental difference between the shvuah of the father, meaning the Malva himself if he were alive, and a shvuah of the Yisomim of the Malva in event that the Malva is gone. The Malva could claim with a shvuah in 100% certainty that he was not paid up for this loan. His Yisomim, on the other hand, at best could take an oath that our father never told us that this shtar was paid up. He never told us that so-and-so paid up. But they don't know for sure that the loan was outstanding and not repaid. And therefore, Rav Ushmul the Amrit Shavai lo shanu el shemeis malva v'chai lova avol meis lova v'chai malva kvar nischayev malva livnei lova shvu v'eino the mora shvu lebana. In a situation where the lova died during the lifetime of the malva, if the malva himself were to come to the Yisomim of the lova and claim payment on the loan, that the debt is outstanding, he, the malva himself, would have to take a shvuah. Because Rabbana made a takana that ein nifra minitza Yisomim below shvuah. You can't collect from Yisomim without a shvuah. So the malva himself, therefore, since the lova died, and he, the malva, wants to claim payment from the Yisomim of the lova, he would have to take a shvuah. Now the malva dies, and Shmuel and Rav have the opinion, ein other morish shvuah lebana. The malva, if he were alive, could have taken a shvuah's vadai. Certainly I was not paid up. His orphans, on the other hand, after his death, could not possibly take a shvuah's bari, a shvuah's vadai, and claim we know 100% sure, with all certainty, that the loan was unpaid. They can't know that. They can at best say, well, our father didn't tell us it was paid up. So that's the principle that's coined here, the matbea of Rav and Shmuel, Eino the Morish Shmuel Abana, that if he, the malva in his lifetime, would not be able to collect this chov without a shvuah, then he cannot pass over that shvuah to his yarshim, that they would inherit the shvuah and they would be able to take that shvuah. They can't take the shvuah that their father would have taken. Now, is there a bar plukta that rejects Rav and Shmuel? Yes. Shalchu akami to Rabbi Eliezer. The question was sent to Rabbi Eliezer. Shvua ma'zutuva shalchu lo yarshin ishpaim shvuas yarshin minot. So Rabbi Eliezer takes the opposite view. He rejects the sheet of Rav and Shmuel, and he says, you know what? The Yarshim are not capable of taking Shvuas Vada. They can't say certainly the loan was unpaid, but they can give us a good, solid Shvua that in all likelihood it really looks like the debt was not paid, because otherwise the father would have notified the children. And therefore, Rabbi Lazar, in opposition to Rav and Shmuel, maintains that Adam Morish Shvuah Lebanov, which the chiddush of which is that even though the father would have taken a Shvuas Vadai, we nevertheless trust and rely upon the Shvuas Safek of the Yarshim. Now, during the course of today's learning in Mitzvah, we're going to see a whole question about whether we pass like Rav Shmuel or whether we pass like Rabbi Lazar. Shalchu b'mei Rabbi Ami, Omar Kuli Hai Shalchu Levi Asli. You already sent this question to Rabbi Lazar. He gave you an answer. Why are you sending me the same question? However, nevertheless, if I had an explanation or perhaps a support for Rabbi Lazar, I certainly would have sent it to you. But Elam Rabami, nevertheless, he says, since you sent me the question and it's here on my table, is name about Milsa, let me say something, meaning I have something to add. And what is that? What happens if the Malveh sued the Yarshim of the Love during his lifetime, and this took place in court? Now, the moment that the Malveh puts forward his lawsuit, his complaint, his claim against the Yisomim and the Love to collect his halva, at that split second of Hamada B'Din, when he's up in front of the court, he has a Chiyuv Shvuah. Because Ein Nishboim Minichse Yisomim El B'Shvuah. Is therefore, Amid B'Dinu Meis, if now the Love dies, if now the Malva dies, after already the Bezdin was ready, eager, and waiting to impose a Shvuah on the Malva, is Nischayev Malva Lifnei Love Shvuah. Again, even though Bezdin didn't yet paskin and rule explicitly what's the word I'm looking for? Obligating the Malva to take a Shvuah, but nevertheless, once it gets to the hands of Bezdin, and the Malva registers his claim against the Yisomim of the Lova, at that point there is sort of potentially or lurking in the shadows a Chiyuv Shvuah, and a Dobar Shvuah L'Bana. But Lo Amid B'Din V'Mes, if on the other hand the Malva died, and the Malva never had that Chiyuv Shvuah, is then we have halacha that you can't collect from Yisomim without a Shvuah, therefore Yarshim Nishbar Shvuas Yarshim Enotli. Let the Yarshim of the Malva take a Shvuah and collect from the Yarshim of the Lova. Again, that Shvuah will not be identical, as we said over and over again, with the Shvuah that the Malva himself could have taken, but nevertheless, according to Ravami, it suffices. So now what the Gemara is going to attack the premise, the underlying assumption of Rabbi Ami that the koveh, the determining factor, is whether there was Omad B'Din or not. Maskif lo Rav Nachman, I don't get it. Atu Beidino Kamachayve L'Shvuah, does it depend upon whether they got to Bezdin or not? May India the Shachiv Lov, when the very moment the Lov died, and at that point there's no way of collecting the Chov other than going to the Yarshim. Is he chayv lemalva lebnei lo v'shvuah? We have a principle that you can't collect from the Yisomim without a shvuah. So really, the chiyuv shvuah that's imposed on the malva is chal immediately with the death of the lova, and we don't have to wait until hamada b'din, until there is a court case. Elamar of Nachman, and therefore of Nachman rejects Rabbi Ami and presents the following. We call in Yiddish other, meaning it's either this way or that way. Rav Nachman doesn't come to a definite conclusion. He says the following: if you're going to accept the opinion of Rav Shmuel that Ein Adam Morish Shvuah L'Banav, is Isa. Okay, then apply that principle the very moment that the Lova dies, even before Hamad B'Din. Lesser, but if on the other hand you're going to accept Rabbi Lazar against Rav Shmuel, you reject Rav Shmuel, then lesser. Then even if there was already a Hamad B'Din, and even if the Malva already, after standing in front of the courts, they imposed upon him an obligation to take a Shvuah before he died, but Adam Morish Shvuah L'Bana. That's the Shita of Rabbi Lazar. Alma, the Gemara says, Mesafkale. You see that Rabbi Elazar doesn't know. I'm sorry, Rav Nachman doesn't know, and he vacillates back before that is whether we paskin like Rav Shmuel, ain't other Morish, or we paskin like Rabbi Elazar, other Morish. Rav Yosef Bar Ben Yomi. We saw this already once before. Avad Rav Nachman, Avad Rav Nachman Uvda, and he paskin Yachloku. Now, a case came up, an actual case in the courts of Rav Nachman, and if Rav Nachman would have accepted the opinion of Rav and Shmuel, then the Yarshim of the Malva would have no recourse to collect anything from the Yarshim of the Lova because they know them Morish Shmuel Abanav, and yet Rav Nachman in that particular scenario, in that case, Paskin Yachloku. So we see for sure that Rav Nachman rejected Rav and Shmuel, and the Gemara says no, that's not necessarily so. The Dvar of the Rabbi Meir Ka'amar. Rabbi Meir was the one who said, "Amotzi mechavel of Haraya Yachloku." And Rav Nachman, although he was telling us what Rav Meir would say in this case, but Ihu Lesle Svile, Lay Lo Svile. He never accepted La Halacha, the opinion of Rav Meir. On the contrary, if you remember Rav Yossi against Rav Meir, we always paskin in favor of Yossi, and Rav Yossi ruled. Then in this case, just one second. So again, Rabbi Meir would say that the Yarshim of the Malva have no recourse whatsoever to collect money because they can't take the Shvuah, ain't other Morish. The Yisomim of the Loa can't take the Shvuah, and then we apply the principle of Chazra Shvuah L'Sinai, and we leave things status quo, which means that according to Rabbi Meir, the Yarshei Malva cannot collect anything. However, Rav Nachman himself never accepted Rabbi Meir, and he himself would hold, like Rabbi Yossi, that in this case we paskin Yachlok. Masiv Rav Oshaya. Now again, we're asking a barrage of questions against Rav and Shmuel, and in this case, the kash is being asked from a Mishnah, and we'll see a whole slew of Mishnayos by Rav Oshaya from Maseches Ksubos. Mesa. Okay, now we have a case of an almana who should be collecting her ksuba from the Yarshei Abal, but now she dies. So now we have the Yarshei Abal, and we have the Yarshei Ha'isha, and they're, so to speak, contesting the ksuba. Is Yarshei Maskirin es ksubasad esrim v'chamesh shanim. So her Yarshim, who now want to collect the ksuba, they have a limit in time. We give them an extension of 25 years. And the same thing would apply to the mother if she were alive. We give her 25 years to collect, to claim to register a claim on her ksuba. If 25 years goes by, then we assume she was mocheles es ksubasa. And the same rule is going to apply to her Yarshim. If they don't come around to Bezdin to put forward and register their claim, then 25 years goes by. I think there's some similar law in secular law, but I don't know if it's 25 years, whatever it is. Then the implication is that they were mocha. So now, what would be if the Yarshim of the Isha would come to collect their ksuba within the 25 years? Now, we're talking about an almana, am I right? Just 1 second. Does it say the word almana here? Let me see. Well, anyway, we're talking about an almana. So he died. His wife, if she would be alive, when she puts forward a claim to collect taksub within 25 years from his Yorshim, she would have to take a shvuah. Because ein ishbain minichsa yison below shvuah. Ein ifroy. I mean. So now, when she dies, who's going to take the shvuah to collect from the Yorshei Abal? It's going to have to be her Yorshim. But Rav and Shmuel said, ein adam morish shvuah lebanav. So how could it be that the Yorshim of the Isha would collect from the Yorshim of the Baal with a shvuah? It's against Rav and Shmuel. So the case was where after her husband died, she took a shvuah to support her claim against his Yarshim and collect her ksuba, and she died. So since her shvuah was already registered in Beis, then even Rav and Shmuel will agree in that case that her Yarshim would collect the ksuba on the basis of her shvuah. Tashma, we have another Mishnah in Ksubas. Nasa Rishona Umesa. Oh, now here's an interesting case. We have two sets of Yarshim who are vying for the Ksuba. Because the man was married to two wives. Now, he had sons from the first marriage. His wife died, he remarried, and he had sons from the second wife. So the Mishnah establishes that Shnia v'Yarshea kodmim li'Yarshe Rishon. It's a little bit counterintuitive, but maybe I'll just give an introduction so we'll have an idea what's going on. There's something called Ksubas Banin Dichrin. There's a special takana within the context of Yerusha and Ksuba that a man makes a stipulation. Well, I shouldn't say his stipulation. It's actually a Tanai Bezdin. Bezdin stipulates that if he had sons from wife number one, then those sons have rights to inherit their mother's ksuba. But that's a special takana. Now, the first wife dies during the lifetime of her husband. He gets remarried and has children from the second wife. So the Yarshim of the second wife have superior rights over the Yarshim of the first wife, because the Yarshim of the first wife have a special takana which we call Ksubas Banin Dichrin, whereas the Yarshim of the second wife, they are collecting the chov that the father owed. Again, it was a conditional chov on the condition that he dies. He died. Now the chov is completely valid. So that chov takes precedence over Yerusha, because Ksubas Banim Dichrin operates through the mechanism of Yerusha. In any event, the Mishnah states that if now she dies, and we're talking about the second wife, then her Yarshim will collect the Ksuba. Now that's strange, because she in her lifetime would have to collect her Ksuba with a Shavuos, because she's collecting from the Yarshim of the Baal, and ain't it from Elam Shua, right? And now if the Yarshim of the Shnia will collect the Ksuba, they can only do so with the Shvua, and that's against Rav and Shmuel because Ein Odom Morish Shmuel Abana. So more answers Hachanami, the same answer, should Nishba Umesa, that before she died, she took the Shvua. Toshma, another Mishnah in Ksubis. Now here's a case where a man stipulated at the time of the marriage that his wife or anyone who comes, let's say a buyer who bought her ksuba or her yorshim, can collect without a shvuah. That's what he stipulated, and that he could do. So her yorshim now do not have to take a shvuah. So the Mishnah says, "Aval yorshim mashbiim osav es yoshev es bonim haboim birusha." That stipulation, which the husband made, that there won't be any shvuah, that only applies if he's alive. Just one second. Aval Yarshim, Yarshav, Mashbir, Osav es Yoshev es. Right. So he, by virtue of stipulation, he gave up and forfeited his rights to demand a shvuah. But if he dies, then his Yarshim, when she comes to collect her ksuba, or her Yarshim come to collect, or her buyers come, they have a right to demand a shvuah. So the father gave up on his rights to demand a shvuah, but he cannot give up the rights of his heirs to demand a shvuah. But at the end of the day, the heirs of Haksuba will collect Haksuba from the heirs of her husband after they take the shvuah. And that's against Rav Shmuel, who hold that Ein Odom Morish Shvuah Labana. Omer of Shmaya, Litzdadim Ktani. We have to sort of reinterpret that Mishnah. The Mishnah teaches two different dinim. Number one, Osa Bialmana. When it says that after the husband dies, his Yarshim could force a Shvuah, and therefore she's an Almana, for her husband dies, and she has to collect a ksuba. And the Yarshim of the father have a right to force her to take a shvuah, to demand a shvuah. However, when the Mishnah says, Mashbin also Yoshel begrusha, if let's say the father had divorced his wife, and with divorce, she, or when she dies, her heirs will collect the ksuba. So we're dealing with a case of a grusha almana, meaning she was first divorced, and then she died. So in such a case, she never had a chiyuv shvuah to take a shvuah to claim under oath that the ksuba was never paid. And therefore, her Yarshim could collect from the Yarshim of the Baal based on Shvuas HaYarshim. And it's not a matter of Morish or Eino Morish, which would mean that according to Rav and Shmuel, they could not, the heirs of the Isha could not take a shvu to collect their ksuba. No, 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 no. We're talking about a case where she was divorced, and in that case, she never had a chiyuv shvu. Maser of Nachman bar Hoshaya, we have another brayso that says Yofa kocha ben mi kocha a.